When you serve in the military, your career, your honor, and your future can all hinge on a single moment. If you've been accused of a drug offense under Article 112 Alpha of the Uniform Code of Military Justice, you need to understand exactly what's at stake and what you can do about it. Here's what we'll cover. First, what Article 112 Alpha actually says and what it means for service members. Second, the real-world consequences and what the prosecution has to prove against you. And finally, how urinalysis plays such a big role in these cases and the defenses that could protect your career. Let's start with the basics, because before you can defend yourself, you need to know exactly what you're up against. Article 112 Alpha makes it a criminal offense to wrongfully use, possess, make, distribute, import, or bring controlled substances onto a military installation. That means not just illegal drugs like cocaine, heroin, or methamphetamine, but also marijuana, even if it's legal in your state, and certain prescription medications if you don't have a valid prescription. The penalties can be severe. For simple possession or use, you could face up to 5 years of confinement. For distribution, the maximum can jump to 15 years or more. On top of that, there's the possibility of a dishonorable discharge and losing all pay and benefits. To convict you, the prosecution has to prove two things: that you knew you were using or possessing a controlled substance, and that you did it without any legal justification or authorization. One of the most well-known defenses in Article 112 Alpha cases is called innocent ingestion. The standard is clear. The government has to prove you knew what you were doing. Negligence, foolishness, even flat-out stupidity. None of that is enough on its own. But this area of the law is tricky, and that's why having an experienced military defense attorney on your side is so important. Most drug cases in the military don't begin with someone caught in the act. They begin with a urine test, random testing, a unit sweep, returning from leave, even medical treatment can trigger a sample. That's why it's so important to know which substances are banned and how everyday things like CBD, hemp, or mislabeled supplements can still lead to a positive result. But a positive test result doesn't always mean the case is airtight. Every urinalysis has a chain of custody, a record of how your sample is handled from collection to the lab. But the chain of custody can have errors and still stand up in court. Scary, right? That's why you need someone who knows what to look for. Someone who can figure out which parts of the process are weak enough to attack in your case. It's important to understand that the military follows the UCMJ, not state law. So even if a drug is legal where you live, like marijuana, it's still prohibited for service members. And the consequences are based on the UCMJ, not local statutes. If you've been accused under Article 112 Alpha, act immediately. Gather any evidence you have, write down every detail, and identify anyone who can back up your story, and get qualified legal help as soon as possible. An accusation under Article 112 Alpha can change everything, but you still have options. The sooner you act, the stronger your defense can be. Contact Kral Military Defense today, and let's start protecting your career, your honor, and your future.